Hi students, welcome to my channel and our teachers. So today's topic of discussion is Indian citizenship. Citizenship part 2 of the constitution. The part 2 of the constitution deals with the Indian citizenships. So like any other modern state in India, India also has two kinds of people. One is citizens and the other is aliens. The citizens are like the people of India. So the citizens are like full members of the state and they owe some allegiance to it, whereas aliens are citizens of some other states. So there are in aliens also there are two kinds of aliens. One is friendly aliens. Friendly aliens are the citizens of the countries which has cordial relations with India, whereas the other kind of aliens are enemy aliens. These are the people these are the citizens of the states which are at war with India. So this is the difference between the friendly aliens and the enemy aliens. So the Constitution of India confers certain rights to the citizens of India, whereas it denies the same rights to the aliens. Either it may be the friendly aliens or enemy aliens. So certain rights has been only confined to the citizens of India, where it has been denied to the aliens. So in those rights, one is right against discrimination on grounds of religion, race, caste, sex, place of birth. That is Article 15 of the Constitution. So this right is not available to aliens. It is only available to citizens. And the other is right to equal opportunity in case of public employment. So the aliens, the friendly or enemy aliens, does not have the right to apply for the public employment as compared to the citizens of India. This article 16 is also available only to the Indians, whereas right to freedom of speech and expression and assembly, association, that are articles 19 clause 1 clause sub A, B, C, D, E and F. These six rights under Article 19 are exclusively available to the citizens only. They are absent to the foreigners. And the other articles are Article 29 and 30, cultural and educational rights, available only to the citizens of India. And some other legal rights are like right to vote in elections to parliament or state legislatures or any other elections like local elections. These rights are not available to the foreigners. That is right to vote. Vote is not available to foreigners, whereas it is only exclusively available to the citizens of India. And the right to contest for any seat, either it may be parliament or state legislature or any local body elections, these are not available to the foreigners. And right to like eligibility to hold certain public offices like president, vice president, and Supreme Court judges, election commission, election commissioners, etc., other constitutional and statutory posts. These are exclusively available to the citizens of India. The aliens, the foreign citizens does not have the eligibility to apply or eligible to hold these public offices. So the articles which are exclusively available are Article 15, right against discrimination on grounds of religion, caste, sex, place of birth, and Article 16, public employment, and Article 19, that is right to freedom of speech and expression, assembly, the association, right to form assembly, association, and Article 29 and 30, those are cultural and educational rights, vote in elections, and contesting elections, hold public offices. So these are the exclusive rights that are only available for the citizens, not for the foreigner states. Other than these, every other rights and political or legal rights are available to both citizens and foreign citizens. So along with the above rights, there are some duties mentioned in Article 51 Clause A of Indian Constitution. Like these duties has to be performed by the citizens of India. That is, they owe like they owe they they are like they are bound to do these duties. Some of these duties I can say is respecting the national flag and national anthem, and defending the country when called upon so during the times of war, and paying taxes, etc. So these are some duties which are uh, which are which the citizens have to do, whereas the foreigners doesn't have obligation to do these duties. So these are the rights that are enjoyed by the that are exclusively to the citizens of India compared to the foreigners. These are provided by the constitution itself. So next comes to the uh, citizenship. As we discussed, the citizenship of India is a union list, is under union list, under seventh schedule of the constitution. Constitution. What does this mean? Parliament has the exclusive power to make laws regarding citizenship. So the state government doesn't have the power to make any laws with respect to the citizenship. This falls under the union list. And Indian citizenship is a single citizenship. We don't have dual citizenship unlike USA. Unlike USA has double citizenship, dual, where in USA a, a person is a citizen of United States of America and also the citizen of the states. Whereas in India a person is citizen of the India only, not a citizen of any state, not a citizen of any state. He is only citizen of India. That's the difference between single citizenship and double dual citizenship. So India has only single citizenship. We don't have any double dual citizenship, and Indian citizens cannot hold citizenship of any other countries parallelly. So Article 5 to 11 of the Constitution deals with the citizenship. So what does this article tells? These articles tells that any person is a citizen of India at the commencement of the Constitution. So these articles does not tell about the citizenship of a person after the commencement of the Constitution, that is January 26th, 1950. So any person who is born after or came to India after January 26th, 1950 will be will become citizenship by law made by the Parliament of India. So Article 5 to 11 deals only with the citizenship of the citizenship do, before or before the commencement of the Constitution. So let's come to the Article 5. At the commencement of the Constitution, every person who has domicile in India and has fulfilled any of the three conditions. First condition is he has to be domiciled in India. If he was, and any of the three, if he was born in India, he can become a citizen of India at the commencement of the Constitution. Either of his parents were born in India, and he has been ordinarily resident in India for 3 years immediately before commencement of the Constitution, that is 26th January 1950. Before this date, he has to be ordinarily resident 5 years in India. If any of these three conditions is fulfilled, any one, and he has domicile in India, then he will be a citizen of India. So next we go to the Article 6. Article 6 is like migration to India. During separation of during separation, like India and Pakistan, when they were separated, there happened a huge migration from Pakistan to India and from India to Pakistan, that is across borders. So people who migrated from Pakistan to India, any person who has migrated to India from Pakistan can become a citizen of India if the following conditions are fulfilled. That is, either of his parents or grandparents were born in undivided India. So any person who has migrated to India from Pakistan, he will become a citizen of India if his either of his parents, any of his parents, father or mother, or his grandparents, were born in undivided India, that is combined India and Pakistan, and also any of the following two. This cutoff date is important: 19th July 1949, 1948. So before this date, he has been ordinarily resident of India since migration. So like he has migrated to India before 19th July 1948 and has ordinarily been resident in India since migration, then he can be citizen of India if the first condition is fulfilled plus this condition, or this: after 19th July 1948 he has to ordinarily resident in India 6 months. This 6 months is not there in earlier case. Before like if he comes before 19th July 1948, he is residing in India continuously, then there is no like time limit mentioned, like 6 months is mentioned for his citizenship. Whereas if he comes after 19th July 1948, he has to reside 6 months before preceding the date of his application as citizenship. So this is, so either this condition or this condition has to be fulfilled to call him as a citizen of India. So the next Article 17 tells that we have discussed that people have migrated from Pakistan to India and from India to Pakistan. So people who migrated from India to Pakistan, but due to some uncertain conditions, they have returned back to India. So they have returned back to India. So Article 7 tells about those people. The people migrated from India to Pakistan and later returned to India. This article deals with those people. So who migrated to Pakistan after 1st March 1947 before independence and later returned to India can become citizen of India if the following conditions were fulfilled. If if he has to ordinarily resident in India for 6 months, this condition is necessary before preceding the date of his application as citizen. So if a person has moved like migrated to Pakistan before 1st March 1947 and later after 1st March 1947 he returned to India. So this is basically the Article 16th, Article 6th, second clause, where he has after 19th July 1948, 1948, this condition has to be met if he has migrated from India to Pakistan and returned to India. So this is what Article 6 tells about. So what does Article 8 tells about? Article tells about persons born outside India. Born outside. So they are not either migrated to Pakistan nor they migrated from Pakistan to India. So this talks about the persons who are residing in other countries other than India and Pakistan. A person or sorry, any of his parents or grandparents were born in undivided India, but who is ordinarily residing outside India shall become a citizen of India if he has registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence. So, when a person whose parents or grandparents were born in India, undivided India, and he has been residing in another country, his he will become the citizen of India if he has registered as a citizen of India by the diplomat or consular representative of India in that country. So if he is born, he has to register himself as the citizen of India at diplomat or consular representative of India in that country. Then only he will be regarded as the citizen of India. So then what else Article 9 tells about? No dual citizenship. We have discussed this earlier. Indian citizenship is single citizenship. We don't have dual citizenship. So, if any person has voluntarily acquired the citizenship of any foreign state, then he shall not remain as the citizen of India. So, voluntarily acquired, what does this mean? If he has acquired consciously or with due knowledge, if he has acquired the citizenship of any foreign state, then he shall not remain as the citizen of India. You see, this tells about the dual citizenship. So, this tells about the single citizenship of India. And what about 10th one? Parliament to decide on who is the citizen of India. Parliament decides who shall be the citizen of India. So, through laws made by the Parliament. So, Article 11 gives the power, it gives the Parliament the power to the Parliament to make provisions with respect to the acquisition and termination of citizenship and all other matters related to citizenship. Only Parliament has, only this power was given to Parliament, not to state legislatures. So only the parliament has the power to make provisions with respect to the acquisition and termination of citizenship and all other matters related to the citizenship. With this power, the parliament has enacted the Citizenship Act of 1955 for acquiring, for laws related to the acquiring and termination of citizenship, the provisions related to the acquiring and termination of citizenship of persons, which was amended from time to time with changing need. This act was amended in 1986, 1992, 2003, 2005, and 2009. The latest is Citizenship Amendment Act of 2019. So, if we come to the next, we have discussed that in the previous slide, we have discussed that Citizenship Act was passed in 1955 to make provisions regarding the acquisition and termination of citizenship. So what does this is? This act provided 5 ways of acquiring citizenship. Acquiring citizenship, that is, one is by birth, by descent, by registration, by naturalization and incorporation of treaty. Let's see about each provision in detail. First, by birth. So by birth. So this act deals with the persons who are born after commencement of the constitution, because the articles deals with the citizenship of the persons before commencement of the constitution. So we have to make provision. The parliament has made provisions regarding the citizenship rules, acquisition and termination after commencement of the constitution. So these dates are important. These dates begin after commencement of the constitution, that is 29th Jan 1950. So born after 26th Jan 1950 and before 1st July 1987. So these dates are important. A person born after this date is citizen of India irrespective of his parents' nationality. So any person who is born after 26th January 1950 before 1st July 1987 will be citizen of India. What happens born after 1st July 1987 is considered as Indian citizen only if is either of parents or citizen of India. So these are two conditions. Born before 1st July 1987, he will be citizen of India irrespective of his parents' nationality. Whereas born after 1st July 1987 is considered as Indian citizen only if his either parents were citizens of India. So there was another thing. When the amendment was made in 2003, this was added on born after 3rd December 2004 shall be citizens of India if both of his parents were citizens of India or one of his parents is a citizen of India and other is not an illegal migrant. So this condition tells that he can become a citizen of India if both of his parents were citizen of India, or else either of his parents was citizen of India and the other parent is not an illegal migrant at his time of birth. This the citizenship by birth does not apply to the foreign diplomats who posted in India or foreign nationals who are serving in India for their country or foreign diplomats posted in India. The children of the foreign diplomats born in India does not eligible for citizenship by birth. So next comes to the citizenship by descent. So this talks about the citizenship by descent. Person born outside India. This is like descent means who are descendants of India but living abroad. Descendants of India living abroad. This provision talks about them. So someone who is born outside India after 26th January 1952 before 10th December 1992. If his father was a citizen of India at his time of birth, he can be eligible for citizenship of India. What happens if he was born after 10th December 1992? If either of his parents were citizen of India at his time of birth, here it has to be the father. Here either of his parents, either it may be mother or it may be father. What happens? This added by 2003 amendment after 3rd December 2004. If his birth has been, suppose a person born outside India, if his birth has been registered at an Indian consulate within 1 year of birth or with the permission of central government. If his birth is registered within 1 year, he will be the citizen of India by descent. If it is not registered, then they have to take permission from central government. These are two conditions. Government of India for making him as the citizen of India. So citizenship by descent is like 1950 to 1992. His father has to be the citizen of India. After 1992, either of his parents can be citizens of India. But after December 3, 2004, a person born outside India, his birth has to be registered at Indian consulate or a special permission has to be taken from the central government. Next, by registration. A person who is not a citizen of India can become a citizen of India through registration. So central government may on an application and register as any person as a citizen of India, not an illegal migrant. Not no illegal migrant can become a citizen of India by registration if he belongs to any of the following. So for registration, the conditions are this: a person of Indian origin is ordinarily resident in India for 7 years before making an application. Before making an application, he has to reside in India for 7 years. Ordinarily resident in any country or place outside undivided India. In any country or place outside undivided India, he has to be ordinarily resident. A person married to a citizen of India and is ordinarily a person married to citizen of India, like he might be any citizen. If he's married to citizen of India and he's ordinarily residing in India for 7 years, then he can apply for Indian citizenship through registration. Citizens of minors, minor children of minor children who are citizens of India. The children who are citizens of India, children whose parents are citizens of India can become the citizens of India through registrations. Persons of full age capacity whose parents are citizens of India. A person whose parents are parents are citizens of India, he can register himself through. He can become citizenship of India through registration. A person's full age and capacity whose either parents were citizens of India and is resident for 12 months before registration. So same as the before class, but he has to stay in India 12 months before his registration for citizenship. A person who is an overseas citizen of India for 5 years and is ordinarily resident in India for 12 months. So a person who is an overseas citizen of India for 5 years, that is a person possesses overseas citizen of India card hold for 5 years and is ordinarily residing in India for the preceding 12 months of his registration, he can become the citizen of India through registration. Note, this is the condition that must. All the above categories of persons who have applied for the registration, who have applied for the citizenship registration, must take an oath of allegiance before they become they are registered as citizens. That they should take an oath of allegiance to the country before they are registered as citizens. So this is citizenship by registration. Then comes naturalization. So government may on application grant certificate of naturalization. Any person who is residing in India can become citizen through naturalization. It's like they have stayed in India for a quite long period of time. There they will be given Indian citizenship, but not to an illegal migrant. Illegal migrant cannot become Indian citizens either through registration or through naturalization. So, what are the conditions he has to fulfill? He is not subject to citizen of any country where citizen of India are prevented from becoming the citizen of that country by naturalization. If a person who is residing in in India, if he is from a country, suppose he is from a country X, where Indians are not allowed to become citizens through naturalization, then he is not eligible to become the citizen of India through naturalization. This is one clause. If he is a citizen of any country, undertakes to renounce the citizen of that country. When this person becomes an Indian citizen, he has to undertake the oath to renounce the citizenship of that country, because Indian citizenship is a single citizenship. It does not allow dual citizenship. He has to reside in India or has been in service of government of India fully or partly throughout the period of 12 months. This period is important, preceding the date of application for naturalization. So he has to either reside in India or been in service or partly throughout the period of 12 months preceding the date of application. So this 12 months is important. And during 14 years of his, I told you right, for naturalization, the person has to reside in India for a quite long period of time. So 14 years, that is 14 years. This is called life imprisonment. So life of a person is calculated according to the law as 14 years, immediately preceding the said period of 12 months. Like 14 years he has to reside in India, and in the preceding uh, 12 months before uh, 12 months before his application, he has to reside in India, and he has been in 14 years, he has to be continuously resided in India for 11 years. So these are the three important durations or periods for this clause. And he is of good character. This is subject to this subjective thing. So he is of good character. And another thing is he has an adequate knowledge of any language in the eighth schedule. The eighth schedule deals with the languages of the India. It contains 22 languages. He has to has a knowledge on at least one language. So these are the uh, following provisions uh, through which a person can become the citizen of India through naturalization. There are some important notes. Government of India may waive all or any of the above provisions in case the person who has rendered distinguished service is important. Distinguished service to the science, philosophy, art, literature, world peace, and human progress. These six things are important. One is science, philosophy, art, literature, world peace, and human progress. So these things, so government of India can waive above all these six provisions if he has he has rendered distinguished service in the field of science, philosophy, art, literature, world peace, and human progress. And another condition is every naturalized citizen must take oath of allegiance to the Constitution of India. He has to take oath of allegiance to the Constitution of India. If he doesn't take the oath of allegiance to the Constitution of India, he cannot become the citizen of India through naturalization. So next is through incorporation of territory. What does this mean? India, like if any foreign territory, since India is a sovereign state, it can occupy foreign territory, or through an agreement it can exchange foreign territories, any foreign territory can become part of India. So if any foreign territory becomes a part of India, then government of India specifies the persons who among the people of that country shall be the citizens of India. Then such persons become the citizen of India from the notified date. This is simple. Example, I'll give you the Pondicherry citizenship citizenship order. Pondicherry in before nine after like in 1962, the Pondicherry has been added to the Indian Union. So through citizenship Pondicherry order under the Citizenship Act of 1955, the people of Pondicherry became the citizens of India. Similarly, Goa also. So there is some special provisions been asserted to the Assam Accord. So during the liberation of Bangladesh, many people have migrated from Bangladesh to the neighboring states of northeastern states, the neighboring states like Assam, Meghalaya, Tripura, Nagaland. So the major people have migrated to Assam. So the people of Assam have revolted against, like revolted, and the government has like signed the Assam Accords with the people of the government of Assam and the people Assam Liberation Organization. So this gives special provisions to Assam. So this is amended by the Citizenship Amendment Act of 1985. All persons of Indian origin who came to Assam after January 1st, 1966 from Bangladesh shall be citizens of India. So after first 1966 till, oh sorry, this is before 1st January 1966 from Bangladesh shall be citizens of India, and persons who came after January 1st, 1966 but before 25th March, then this is liberation of Bangladesh, the day of liberation of Bangladesh. So this date, before this date, shall be registered himself to the citizen of India, and this registration is valid for 10 years. During this period of his registration, he is not eligible to vote in the elections. So after these 10 years, he will become the citizen of India. For these 10 years, he is just like it is like he is registered for citizenship of India. He is a citizen of India, but is not eligible to vote. After 10 years, he is eligible to vote. So what is loss of citizenship? In the previous slide, if he is not eligible to vote, it also means he is not eligible to contest elections also. So then loss of citizenship. So the Citizenship Act of 1955 tells that Indian citizenship can be lost in three ways. A person can lose Indian citizenship in three ways. That is by renunciation, when he himself announced that I am not a citizen of India; by termination, where the government of India terminates the citizenship of India; and by deprivation. So first we'll talk about the renunciation. Any citizen of India with full age and capacity can make a declaration renouncing the citizen of India. Minor children cannot, a declaration of minor children cannot be taken as a renunciation of citizenship of India. That is, he has to has full age and capacity. Then only that declaration renouncing the citizen of India will be taken into consideration. Upon that declaration, he ceases to be the citizen of India. If that declaration came during in in during a war where the Indian state is in war, then that declaration can be withheld by the government of India. So when a person renounces his citizenship, if India is at war, then that declaration can be withheld by the government of India. And if a person has renounced his citizenship, his minor children also loses the citizenship of India, and they can only apply for Indian citizenship after attaining the 18 years of age. This is citizenship by losing the citizenship of India by renunciation. Next, by termination. Not What is meant by termination? Termination is like when the person accepts the citizenship of another country, he automatically loses the citizenship of this country. So when an Indian citizen voluntarily, consciously, or knowingly acquires the citizenship of another country, his citizenship of India will automatically get terminated. However, this does not apply during India is at war. Sorry, war. I'm trying mistakes. So, so if he has acquired the citizenship of other country voluntarily, like if he has been com, com, compelled to acquire the citizenship of other country, then his citizenship will not be terminated. If it is by force, it is by compulsion, then his citizenship of India will not be terminated. If it is by voluntary, consciously, and knowingly, then only his citizenship will be terminated. This is important. Next, by deprivation, the central government can terminate, like can terminate the citizenship of a person in the following conditions: if he has obtained the citizenship by fraud, if the person has obtained the citizenship through fraud means or through any illegal means, then his citizenship can be terminated. Shown disloyalty to the constitution, if he has shown disloyalty, that he is not uh, like he is not given oath to the oath of allegiance to the constitution, or he disrespected the national anthem, national flag, or any constitutional post or any official post uh, 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 of the Indian government created through constitution. There are many ways he can show disloyalty to the constitution. If he showed disloyalty to the constitution, his citizenship will be terminated. If he has unlawfully traded or communicated with the enemy during war, when India is at war, and if he has is trade communicated, or if he has like leaked any information regarding the India to the enemy, then his citizenship will be terminated. Has been imprisoned in any country for 2 years within 5 years of his citizenship. So in 5 years of citizenship, if he is imprisoned for 2 years, then his citizenship will be terminated. So, and if he has been residing outside India for 7 continuous years, like for 7 continuous years, if he is residing outside India, then his citizenship will be terminated by the government of India. Articles 5 to 11, they deals with the citizenship of the citizenship of the persons before commencement of the constitution, before 26th Jan 1950. And we have discussed about Citizenship Act of 1955, which gives 5 ways for acquiring citizenship and 3 ways to losing citizenship. 5 ways are by birth, descent, registration, common naturalization, and incorporation of territory. These are 5. And this is losing a citizenship is by renunciation, to termination. Third is deprivation. So these are the topics, and we also discussed that Indian citizenship is a single citizenship. India doesn't have a double citizenship, and it is a union list under seventh schedule. Only Parliament has power to make any laws. It can make laws related to citizenship. So these are the entire discussion about the citizenship of India. Thank you. Like, share, and subscribe the video.